Hello and welcome back to American Government and Politics. This is Professor Jonathan Day. In this lecture, we're going to be looking at the courts. So the first thing you need to know about the courts is that there are two types of federal courts. The first is what's called the legislative courts, and these are the courts that are established by Congress under Article 1 to hear cases such as tax law, international trade. They look to see if someone has broken a law and then what their punishment should be. The second type of court is the constitutional courts, and these are the courts that are established in the Constitution by Article 3. And these courts are called the constitutional courts because their job is to review whether or not laws fit within the guidelines of the Constitution, meaning is a law constitutional and it permitted by allowed by the people for the government to implement, or is it unconstitutional and the government has no authority to establish that law? So in Article 3 courts, justices serving in this court have lifetime appointments. Their salaries cannot be reduced while they're in office. So there's two key things about Article 3 courts. What's interesting, though, is that there are no qualifications that are specified in the Constitution for being a justice in the constitutional court, like a Supreme Court or a Court of Appeals or the Federal District Court that evaluate the Constitution. There are no requirements. Anybody of any age, any nationality could sit on a court. The only issue is that they need to be confirmed by the Senate, and so they would need a majority vote of the Senate and the approval of the president and nominated by the president. So why do we give lifetime appointments and say that salaries cannot be reduced by of Article 3 judges? And the reason for this is because the founders wanted to make sure that the judges that were evaluating the Constitution were not biased in any way. So they didn't want them to be beholden to Congress or the president or the people, or to be subject to the whims of the people through elections. They didn't want Congress to be able to reduce their salaries, to punish them. And so the founders made it so that these justices were autonomous in their decision-making capabilities. Okay, so there are three levels to the constitutional courts. The first is the district courts. These are usually heard where federal cases are heard first. If someone wants to say that someone violated their constitutional rights, they would first go to district courts. There's approximately 94 in the U.S. The second level, if your case, whoever loses in the district court, they can appeal it to the appeals court. In the appeals court, there are 12 of these, and each appeals court covers several different states. And so what you need to know about this is that the district courts cover certain geographical district. The appeals courts cover a certain geographical district, but in the appeals court, there's only 12 of them, so their geographical district is much wider. If you look in this map here, it shows that, for example, the seventh appeals court has Illinois, Indiana, and Wisconsin, whereas the sixth appeals court has Michigan, Ohio, Kentucky, and Tennessee. And so once you appeal it from the district court to the appellate court, whoever loses in the appellate court then goes up to the Supreme Court. The Supreme Court is considered the court of last resort because there's nothing above it. There are 9 justices. There used to be 3, and that increased over time till now 9 justices. So with 9 justices, they hear the cases that are appealed to it from the appellate court. And here are the 9 justices that currently reside. We have Amy Coney Barrett and Brett Kavanaugh. Both of these justices were appointed by Donald Trump. Samuel Alito and Clarence Thomas. Samuel Alito was appointed by George W. Bush. Clarence Thomas was appointed by George H.W. Bush. John Roberts was appointed by George W. Bush, and he is currently the Chief Justice of the Supreme Court. Neil Gorsuch was appointed by President Donald Trump. Sonia Sotomayor was appointed by President Barack Obama, and so was Elena Kagan. And then finally, Ketanji Brown Jackson was appointed by President Joe Biden. And so these are the 9 justices of the Supreme Court. If you look at the ideological makeup of these, we have the first 6, Amy Coney Barrett, Brett Kavanaugh, Samuel Alito, Clarence Thomas, John Roberts, Neil Gorsuch tend to vote more conservatively in their opinions. Sonia Sotomayor, Elena Kagan, and Ketanji Brown Jackson, who were appointed by Democrat presidents, tend to vote more liberal. Okay, the Supreme Court has about 9,000 cases sent to it each year. This is the number of cases that are appealed to it from the appellate courts. Usually, they use the Supreme Court justices use their law clerks. They have assistants that are usually from top law schools to help review these cases and bring that number down to about 1,800. From there, they decide which ones they want to hear. They now rule on about 70 cases each year. And why do they rule on only 70 cases per year? Why not all 1,800 or 9,000 that get appealed to it? Well, first, they just don't have enough time to thoroughly review these cases. Each one of these cases has hundreds and hundreds of pages, very complex legal arguments. And so they don't have enough time to look at all of these cases. The other thing is that most of these cases have already been well decided on at the lower courts. There's not really much controversy in terms of what the decision should be based upon past Supreme Court decisions. And also the Supreme Court wants to make sure that its decisions are considered very important. And so by only selecting 70, they make sure that they establish a very solid precedent for all future cases that are being decided at the lower court level. Okay, this is the quick review of a quick direction of how courts come to the Supreme, or how cases come to the Supreme Court. It might start off in lower courts, such as state and local courts. You have the juvenile court, traffic court, small claims court. That might get up to the Court of Appeals at the state level, to the state Supreme Court, and then that might move over to the U.S. Supreme Court, particularly if there's a constitutional issue. For the federal courts, it could start off at a legislative court. These are the federal claims court, tax court, trade, and so forth. That might be pushed up to the U.S. Court of Appeals and then finally the Supreme Court. Or you might go from the U.S. district courts. These are the federal district courts, Court of Appeals to the Supreme Court. Or you may go from the district courts to the State Court of Appeals to the state Supreme Courts, all the way up to the Supreme Court. So there's many different avenues by which a case may go to the Supreme Court, but the primary jurisdiction of the Supreme Court is to determine whether or not the constitutional rights of the people were violated, whether the government made any laws that were unconstitutional. Okay, so how does a court decide of the 9,000 cases, or of the 9,000 cases, to decide which case to hear? Well, there's several different criteria that we know about from past judges' notes and from things that political scientists have found in terms of analyzing this. One is ripeness. The court doesn't like to hear hypothetical cases or cases where the law hasn't gone into effect yet. Mootness. If the law has already been overturned, the Supreme Court doesn't want to hear the case anymore. Collusion. They don't want to hear a case if both parties want the same outcome. Impact. If a case is only going to affect a few people, they would rather hear a case that affects more people, especially if it affects the entire nation. And then finally, the rule of four. Generally, at least 4 justices need to agree to hear a case in order for a case to be heard. Okay, some quick concepts that you need to know. Standing. Standing refers to whether or not a person has the right to sue in court. So if your friend's constitutional rights are violated, your friend has standing in court to sue, but you or your friend or your neighbor do not have the standing to take that case to court. Jurisdiction. This is about whether or not a court can be able to hear a case. So courts have certain jurisdictions. They have a geographical jurisdiction, so they can only hear cases within their geographical boundaries. And they have topical jurisdiction, meaning that they can only hear cases relevant to the type of court that they are. So, for example, a trade court can't hear a case on taxes, or a constitutional court is not going to hear a case about traffic tickets. Precedent is another term. This means that when a judge makes a decision, that establishes a precedent or a standard by which other judges can look at that to make similar decisions on similar court cases. The Supreme Court has establishes very broad precedents for other courts to make decisions. Briefs are a set of legal arguments for why your side should win the court case. Amicus curiae briefs are called, this Latin for friend of the court briefs. Amicus being friend, curiae means of the court. So friend of the court briefs are briefs that are other organizations or interest groups or parties that want a certain case to be cited a certain way can offer supplementary legal arguments for the person who is taking it to court, so that the judge can review additional legal arguments. Oral arguments are where the lawyers defend their arguments through cross-examination of the judges, and so they're asked and answered orally. Okay, finally, the last few concepts that you should know: the majority opinion. The core decision of the court that must be agreed upon by at least 5 justices. The majority opinion presents the legal reasoning of the court's decision. So anytime, this is for a Supreme Court, anytime that you have at least 5 justices agree on the outcome of the case, you have a majority opinion, and that is the final ruling. So who writes the majority opinion? If the Chief Justice is in the majority, then the Chief Justice writes the majority opinion. If the Chief Justice is not in the majority, then the longest standing member of the court has the right to write the opinion. And so they have the right to write the opinion, both the Chief Justice if they're in the majority, or the longest standing member if the Chief Justice is not in the majority. But they can also delegate it out to someone who else is in the majority if they want them to write the majority opinion. The concurring opinion is written by a justice who agrees with the outcome of the case, but not the legal reasoning of the case. And so a justice might agree with the final outcome, but feel that it was a different legal reasoning that should apply in this case. These are not considered the precedent that's established, but it's taking as sort of advice for future court cases. The dissenting opinion is submitted by a justice who strongly disagrees with the outcome of the case, so strongly that they're willing to write down the reasons why the case should not have been decided that way. Dissenting opinions are also important because sometimes they become a basis for future majority opinions, particularly if in the future the Supreme Court decides that their past decision was in fact wrong. They might look to the dissenting opinion as the reason for why that decision was wrong. So this is the major concepts that you need to know about the courts. Thank you so much.